The Trump administration's Department of Homeland Security issued a new memo on July 28th following a decision by the U.S. Supreme Court in June, finding that the administration's 2017 rescission of DACA was arbitrary and capricious. The court's decision restores DACA to its original implementation in 2012. The new DHS memorandum, while saying that it is an interim decision while the administration figures out what to do with the DACA program, drastically alters DACA. This latest move has added to the uncertainty immigrant youth have experienced under this administration. I'll be sharing guidance for DACA recipients and guidance for those who wanted to request DACA for the first time. The July 28th DHS memo directs USCIS to reject any initial DACA requests, meaning from people who have never had DACA before. Individuals who applied for DACA for the first time in light of the Supreme Court decision should expect to receive notice that their initial request has been rejected and will have their application and associated fees returned to them by mail. The July 28th memo directs USCIS to reject advance parole applications from DACA recipients and return them along with their filing fee to the applicant unless USCIS determines the applicant demonstrates exceptional circumstances. It is not clear what USCIS will consider to be an exceptional circumstance. The memo also clarifies that any already approved advance parole issuances will remain valid. If you're interested in advance parole, we recommend you speak to an attorney or a DOJ accredited representative before applying and before you travel outside of the United States, even if you have been granted advance parole. USCIS will continue accepting and processing DACA renewal requests. Those who are eligible for renewal should still consider submitting the request, especially if they have less than 150 days before their current DACA expires. We recommend that individuals consider renewing their DACA, consult an attorney or a DOJ accredited representative who can provide an individualized assessment, including whether they are eligible for another more permanent form of immigration relief. Based on the DHS memo, if your DACA renewal request is approved, your DACA and employment authorization will be valid for 1 year rather than 2. If your DACA and employment authorization have already been approved for 2 years, your DACA and work authorization will remain valid for 2 years, but the next time you apply for DACA, if approved, your new DACA and employment authorization will be for 1 year, not 2. The per application fee remains the same, $495, but this move effectively doubles the cost for DACA recipients and places the burden on DACA recipients to renew every year. This is of great concern because the ability to pay DACA-related fees has long been an obstacle for many DACA recipients, and at a time when many are facing unprecedented financial hardship, this additional yearly fee could hinder eligible individuals from applying, putting at risk their employment authorization and protection from deportation. This abrupt change in the middle of a health and economic crisis to a program that has been in existence for 8 years warrants further the need for Congress to automatically extend DACA and work authorization and to do the same for temporary protected status holders, which is another community whose lives have been upended by the Trump administration's attacks. We'll continue monitoring DACA renewal processing because we are concerned that USCIS's budget problems, as well as the recent changes to USCIS's policy manual, may cause delays in processing. On July 15th, USCIS released an updated USCIS policy manual, creating additional steps for USCIS officers to take. People applying for immigration relief like DACA, TPS, and for work authorization must now show that a favorable exercise of discretion is warranted, in addition to showing that they meet all other eligibility requirements for the specific immigration relief they're applying for. USCIS officers must now evaluate a list of discretionary factors to determine if the person warrants the immigration relief and/or work authorization. For example, what they've done since arrival, ties to the US, and any health issues. We are concerned that this will lead to arbitrary immigration relief denials and even longer adjudication processing wait times for certain immigration relief and work authorization requests, since officers now have to do this extra analysis and document it. All of these things add up to make life as difficult as possible for immigrants trying to navigate an already complex system. This is yet another reason why we need Congress to step in and provide relief. There is a push for Congress to include the automatic extension of DACA TPS work authorization in the next COVID-19 relief bills. So that's the current ask that we're pushing for, given, again, the abrupt change to the DACA program, the inability of people to be able to get legal services right now due to COVID-19, requiring many of these offices to be closed. And of course, the economic situation of our country. So we're really pushing for that. We hope Congress will take that into consideration and make the changes that are necessary to keep people's lives as stable as possible under these unprecedented times. Some members of Congress may hesitate because they don't see much of an urgency around this ask, particularly because people who have DACA can continue renewing it every year, right? But it's still important to make this change because, as I mentioned, now these individuals have to pay every year $495 to continue having protection from deportation and their work authorization rather than every 2 years. So we continue making the ask, not just for those who have DACA, but also for those who are under TPS, who are also able to continue having TPS for select countries only because of courts' interference.